Okay, so we are nearing the end of our program. We are going to begin the third panel here on corporate liability in comparative perspective. My name is Tim Webster. I teach international and comparative law here. And with me are two distinguished guests, and we are going to provide a comparative aspect to this discussion, to this conference. We're going to try to conquer time and space in just 1 hour and 15 minutes, if you can believe that. Let me first briefly introduce my panelists, and then we will go through and we will hear from each of them. In the middle here, we have Professor Tracy Doyle, who is an associate professor at Northern Kentucky University. Professor Doyle holds degrees from Columbia, Cornell, and Indiana, and has been teaching at NKU for a number of years now. Before that, she taught at Howard University and practiced litigation in Garrison Scott in Birmingham, Alabama. Welcome, Professor Doyle. And then at the end of the desk here, we have Dr. Jonas Grimheden, who currently works for the EU Agency for Fundamental Human Rights. Before his tenure there, he has been a visiting professor and visiting scholar in numerous jurisdictions, including the United States, China, Japan, Sweden, Austria, and so on and so forth. I got to know Professor Grimheden when he was a visitor at Cornell, so we are sort of, like it or not, a Cornell panel. Now, when I say we're going to conquer time and space, I mean that in the following way. Professor Doyle will begin the panel by looking at the Alien Tort Statute, which I'm sure many of you are familiar with, at the very least from today's conversations. Then Dr. Grimheden will talk about corporate liability in EU and some recent developments in the European Union regarding corporate liability. And I will end with some thoughts about corporate liability in East Asia. I will state at the outset that one of our panelists, Dr. Anthony Colangelo, canceled about 9 days ago. So the presentation I'm making was concocted in the past 9 days. So I ask for your indulgence on that one. But without further ado, I'm going to turn the panel over to Professor Doyle, and the floor is yours. Thank you.
Thank you so much. Thank you for the invitation to be here. I appreciate that. So I am going to talk about the Alien Tort Statute today, and you will hear some notes a little bit that you've heard before. I hope to deepen one aspect of the conversation, and that is, what will Gessner actually mean in the event that the Supreme Court decides that there is corporate liability pursuant to the ATS, or in the event that the Supreme Court decides that there's not. So the title of my talk is The Cost of Territoriality, Use Kogan's Claims Against Corporations. What I want to do is walk you through a little bit of the Supreme Court's jurisprudence on ATS, but also a case that came out of the Second Circuit, which everyone knows, I think, by now kind of launched the 1,000 ships that has become ATS jurisprudence. So let's get started. We'll see if this is going to work. Is there a mouse in place?
We did do that, the green thing, right? Yep, it says on.
Okay, well, we'll get started. Here we go. Thank you so much.
Is that you, Rob?
That's me. So everybody knows that on October 11th, there will be an oral argument on the case Gessner, which so many folks have been hearing about. And that's the case where the Supreme Court is going to revisit the question of corporate liability under the ATS. You've heard a few of those facts. We know that has to do with allegations of aiding and abetting liability against a bank called Arab Bank, based upon notions that they financed terrorist activity in Israel, the West Bank, and the Gaza Strip. So that case has the potential to certainly answer the extant question about corporate liability, but it also theoretically has the potential to answer some of those other nagging questions out there about the substantive and geographic reach of the ATS, although I'm thinking the court won't reach those questions. So that you can see this very terse statute, I have it here on the slide. You've heard it mentioned by one of the commentators today, but this is all there is to the ATS. This is that statute that in 1980 In the case for Lartiga v. Peña-Arala, the Second Circuit, thank you, the Second Circuit decided that there could be a human rights component to this statute. There could be modern day litigation sustained based upon these few words. And it is simply a jurisdictional statute. It's not anything more than that. It does not provide a cause of action. It simply says that there can be a jurisdiction in the federal courts on the basis of a violation of the law of nations or a treaty of the United States if that cause of action is brought by an alien. So when the Second Circuit said that, they did a few things. They made it clear that an allegation of torture is a violation of customary international law, and they also made it clear, based upon the structure of the claim before them, that a foreign cubed claim could be brought pursuant to the Alien Tort Statute. As a reminder for those who might not know, the foreign cubed claim is the all foreign everything claim, where you've got a foreign plaintiff, a foreign defendant, and foreign conduct. So that was the nature of the Filartiga case. And so we refer to that kind of claim very often these days as a Filartiga type claim because it's a foreign cubed claim. The other thing about this particular case is that it happened to be a direct liability case where the plaintiffs were suing on behalf of the death of a loved one against someone who they accused of directly committing the harm to their loved one. Because of the contours of that case, the other cases that followed often looked like this one. They were also foreign cubed, all foreign everything cases. But they were not only direct liability cases, some of them were also indirect liability cases. And so when Filartiga set sail, it created a circumstance for a large number of ATS cases with all sorts of claim characteristics. As I mentioned, Filartiga concerned a claim of torture. And torture is consistently considered a prohibition of a jus cogens norm. A jus cogens norm meaning a peremptory norm, a norm that has the highest level of respect at international law. It's hierarchically superior to any other norm at international law. And because of that standing, it binds every state and no state can derogate from its standard. So Filartiga also gave us that. It gave us the notion that one could bring an ATS case around a jus cogens norm and it could be treated a certain way. Jurisdiction could be sustained on the basis of this kind of extremely grave claim. You should know that there are other types of jus cogens norms. The fairly clear ones based upon consensus are, in addition to torture, genocide, the slave trade, hijacking, crimes against humanity, piracy, etc. Those are all considered, the prohibitions of those things are all considered jus cogens norms. So as ATS jurisprudence has developed, there's been testing about the propriety of bringing an ATS claim pursuant to these very particular norms. So the cases have looked like Filartiga in terms of their substantive content, but they've also included the norms that I've mentioned. One thing to know as well is that these cases have sought jurisdiction over, of course, corporations as well as over natural persons. They've sought jurisdiction based upon allegations of widespread atrocity as well as on the basis of single event harms. So by the time we get through all of the jurisprudence over the last 20 so years, 20 plus years, we ultimately get to the Kiobel case, the case that so many folks have been talking about this morning. We get to the Second Circuit decision where the court decides that there is no corporate liability pursuant to the ATS, and then that takes us up to the United States Supreme Court that granted the writ for petition of certiorari in that case, and then refrained from answering the question as to corporate liability in the first instance there. Did the second round of oral arguments and briefing in that case and answered the question as to the geographic reach of that case of the ATS, whether the ATS can actually reach conduct that occurs outside of the United States. So in this particular case, and the facts here are very important, you had a set of Nigerian nationals who brought an action against 3 foreign corporations, alleging that those corporations had aided and abetted the Nigerian government in quelling or seeking to quell protest in a particular region of Nigeria, the Ogoniland region. And the allegations go that these 3 companies provided money and property, et cetera, that enabled the government to do the work that netted the harm to the plaintiffs or the plaintiff's decedents. So we're dealing here not with a Filartiga type case per se. We are dealing with a foreign cubed case, but we're dealing with a case where the allegations are against a series of corporations as opposed to a natural person. And we're not dealing with a case of direct liability against the defendants. We're dealing with a case of indirect liability against the defendants. So the Supreme Court decided in this case that the presumption against extraterritoriality, a canon of statutory interpretation, applied to the ATS. So the fact that all of these events occurred in Nigeria became a problem. The court says, there's nothing in the ATS by its terms which says it applies outside of the United States. So the court says, so that's a problem number 1. And if we're going to rebut that presumption, we need a reason to do so. And the court indicated sort of tacitly that there was no reason to rebut that presumption, that all of the relevant conduct that occurred in this case, all of the provision of the money, according to the plaintiff's complaint, the provision of the property for use to stage attacks against the plaintiffs or the plaintiff's decedents, all happened in Nigeria. So the court says there's nothing about this case that has a United States nexus that would warrant displacing the presumption against extraterritoriality. So there we have it. So by the time we get to this case in 2013, we don't have the answer to the corporate liability question, but we do have an answer as to whether the ATS of its own terms allows for an extraterritorial application. And we have the beginnings of an answer. I and others would contend we don't have a full or a clear answer as to whether or how this particular presumption can be rebutted. So you have this very important language in Kiobel. This is in section 4 of the opinion, which is very important because this is what this language here on the slide is all we have to work with when you're trying to figure out what the geographic reach really is of this statute. You see that the court says here on these facts, those facts that I just iterated a moment ago having to do with the allegations of aiding and abetting liability, the court says on these facts, all of the relevant conduct occurred outside of the United States, occurred in Nigeria, and even where the claims touch and concern the territory of the United States, they must do so with sufficient force to displace the presumption against extraterritoriality. So this is the holding. This is the holding. And from this language, subsequent courts have extrapolated their own versions of tests to figure out precisely what was the court getting at when the court issued that language. What should lower courts do when they're confronted with their own alien tort statute case? The court goes on here and talks about corporations being present in many countries and that mere corporate presence is not sufficient to displace the presumption. So we know by that language that this particular holding, certainly in my view, is very corporation-oriented. What does the court not say? The court doesn't speak to natural persons here. The court doesn't clearly enunciate a test, although we can extrapolate a test from that language. So the court seems, in my view, to be very focused on the facts at hand, very focused on the aiding and abetting claim against the corporation for conduct that occurred in toto outside of the United States. So what we know here, in addition to the corporateness of this particular holding, is that it's pretty clear of what it means regarding indirect liability against a corporation. Whether it's clear for a different type of claim, I think, is subject to a little bit of a question. Move this to move along. Okay, so you can feast your eyes on this slide for a minute. So here we go. Thank you. So we know of the one kind of case which this holding covers. It's likely, given the territorial bent of this holding, that it also covers the direct liability claim over a corporation, regardless of the kind of harm that is being alleged by the plaintiff, whether they're alleging a plain customary international law violation or whether they're alleging a use Kogan's violation. So it is, I think, quite conceivable that you can assume that that Kiobel's holding covers everything regarding corporations because in my view, the holding was so corporation specific. It seems less certain that this language, which you've just seen, has to do with another type of ATS case, that type which more closely resembles the Filartiga case, the case where the plaintiff is suing a natural person, the case where the plaintiff is suing that natural person for direct liability, and where the plaintiff is suing that natural person for direct liability for all events that occurred overseas. Why do I think that makes for a bit of a difference? I think it makes for a bit of a difference because the holding seemed so focused on the corporation, in my view, so focused on the facts that were at hand. So keep that in mind for a second. Moreover, what the holding tends not to do in the Kiobel case is speak in the abstract, in a definitive way, so that it is clear to the reader, particularly the other courts, what the breadth is of that particular holding. So 3 years later, we end up with RJR Nabisco v. European Community. This was a surprise to a lot of people because this particular case had to do with RICO. It didn't have to do with the Alien Tort Statute, and yet it contained within it language which is essential going forward for folks who are trying to figure out what to do when they've got a case, particularly one that has extreme foreign features. So here, the European Community was alleging that RJR Nabisco had created this complex money laundering scheme in the European Union, and they wanted to bring and indeed brought an action against RJR Nabisco pursuant to RICO. So the question here was the extraterritoriality of RICO. And the holding, however, or language within the holding, did not center on just RICO. There was an opportunity that was taken by the court to enunciate a broader way of determining when a statute has extraterritorial application. So they gave this framework within step one says that if the statute doesn't say I have extraterritorial application, then you have to go to step two. But if the statute says I have extraterritorial application, well, then that's the end of that inquiry, and you can proceed and apply that statute extraterritorially. But if it says it doesn't have extraterritorial application, then what a court must do is determine the focus of the statute and then determine whether there's conduct relevant to that focus that occurred within the United States. If it does, then the statute can be applied both to the conduct in the United States and to the extraterritorial conduct. The court says if there is no relevant conduct in the United States, well, then you have a problem. So this particular framework is very domestic conduct focused. It privileges territoriality. So what we're left then is a furthering of the notion that the court wants there to be some territoriality, a modicum of territoriality. We don't have a definition of territoriality or the amount that is necessary to have extraterritorial application as well. But we know that looking at Kiobel and looking at RJR Nabisco, you've got to have territoriality for certainly the corporation's cases. So looking at Kiobel and RJR Nabisco together, it's clear about the necessity of territoriality. But if that's true, if you must have a home connection in order to sustain ATS jurisdiction across the board, well then obviously that cuts out a lot of the ATS cases that are typically brought against corporations. If you've also got to have this home United States connection for cases against natural persons, then that too creates an issue given the character and kind of ATS cases that are typically brought. That second point, I think, being subject to a little bit of a question because the court just did not speak in terms of natural person in either of these cases. So the concern here, so the cost of territoriality is potentially the gravest of human rights abuse based claims not being brought in the United States pursuant to the ATS. That's a big deal. So some of the cases that folks have been talking about before, the Doe v. Nestle cases, the Doe v. ExxonMobil cases, old cases like Unical, et cetera, are cases that are unlikely to find ATS jurisdiction. So all of that could be gone. So once you get through Gessner, and if you find that the Supreme Court says that there is corporate liability under the statute, what are we left with at that point? It seems that territoriality and its emphasis has potentially left us with a hollow outcome, even in the event of the court finding that there is corporate liability under the statute. So I'll stop there. I look forward to your questions. Yeah.
Right.
Mm-hmm.
Thank you. Great. So, Jonas, if you'd like to take it away, please.
Thank you very much. This has been a real treat to sit here today and listen and learn, and it has been a lot of learning from my side. So I'm very, very grateful for this day. I want to take you then to Europe and share a bit of the more recent, as Professor Webster was saying, more recent developments from the European Union in particular. And these are the countries of the European Union. I'm sure you know that there are 28 of them, and I want to explain a little bit the complexity of this. I'm sure you know some of it as well. But before doing that, maybe I could, since it's late in the day and we've been here for a while, maybe I can try to amuse you a little bit with a historical anecdote. So we heard this morning about the Soviet Union's contribution to the liability issue. We've heard about the U.S. contribution in many ways to development of international criminal law. And I want to share with you, I'm from Sweden, and I want to share with you how Sweden contributed to the existence of human rights law as a whole. You maybe haven't heard this story, but that's at least how it went. So in 1948, when the Universal Declaration was adopted in Versailles outside of Paris, we heard about this instrument from Judge Bugenthal this morning. There was a committee composed by a few experts from around the world that drafted the Universal Declaration before it was adopted. Obviously, there was a collection effort where they had asked for constitutional rights from around the world, different countries, and they asked for good suggestions to what to include in the Universal Declaration of Human Rights. And then there was, of course, the General Assembly meeting in Versailles where the document was finally adopted. And in the headlines on the 10th of December 1948, or maybe the 11th, in the Swedish newspapers, it said, "Sweden saved the Declaration of Human Rights." And I was intrigued when I saw this. I did some research some years ago, and I wondered, this is really strange because none of the 5 experts, or 5, was from Sweden, and we didn't contribute to submitting any rights. We actually were not very active. It was a very small delegation in Versailles, and we were actually busy with other things in Palestine, and the government wasn't too keen on this instrument. But still, we claimed to have saved the Universal Declaration of Human Rights and provided mankind with human rights law. So why was this? Well, there was one motion proposed by the Swedish delegation in Versailles, and that was adopted, and that was that there should be a 3-minute cap on the speaking time. And of course, if that hadn't been introduced, the French and the Italians would still have been speaking. So that was Sweden's important contribution to human rights law, and that legitimizes, I suppose, my intervention today. So I live and work in Austria, in Vienna, and work for an agency, one of 40 plus European Union agencies with various mandates. Our mandate is human rights, and to provide the EU institutions, the three institutions in particular, and the member states with advice when it comes to human rights. So in the scope of activities of the European Union, where can we advise the most efficiently and in the most needed way? And I'll try to explain a little bit about that, and of course also about business human rights and the developments in the last 2 years. And this is an overview that is very complicated, and that's just to say that the European Union is a complex beast. There's of course the euro members, the currency, the Schengen, the border agreement in Schengen. It's the larger EEA that includes Norway, etc. And there are members that are, or states that are in the process of becoming members to the European Union. And this picture is trying to explain the various groupings. But the mandate of the agency where I work is the 28. And with a bit of luck, there's one more slide here that exemplifies this even more. And I'm using this to say that the first column here is the long list of altogether 47 member states of the Council of Europe. And there's the shorter list of the EU 28, and you have then again the same different constellations that I showed on the previous slide, but also the other organizations, OSCE, OECD, etc. And at least from my experience, it's important to stress the difference between the Council of Europe and the 47 members and the EU 28, especially when I start to talk about the Council of the EU, which is obviously, or maybe less obvious, but an organization of the European Union and the 28, as opposed to the Council of Europe. Another complicating factor with the European Union is, of course, the competence. It's not an absolute authority, the European Union. It has a mandate, the competence only in some areas where it's exclusive. In other areas, it's a shared competence, and then, of course, the member states have their original jurisprudence or the original competence, or what is left when the European Union has taken its share, if you will. And here are some examples of the exclusive and the shared and the national competence. And that, of course, complicates an issue like business and human rights, where you would have some of the rules falling within, or some of the areas of work falling within the exclusive competence of the European Union. Some of it is shared, and some of it is areas where the European Union or the European Commission should push or coordinate, and some is within the member states' jurisdiction. And when it comes to jurisprudence on business-related human rights abuse, I want to draw your attention to some of the recent studies that I've come across. And before doing that, it's important to think of the European Union and the companies that are based or headquartered in the Union, that there are some that are good and some that are bad in terms of human rights. There's a corporate human rights benchmark where you can see that some of those companies included in that benchmark are at the very top, coming from the EU, and some are at the very other end. In terms of cases, we just heard about the Ogoni land, and there have been cases brought before jurisdiction in the European Union, also related to that part of the world. We also have Cote d'Ivoire and Rwanda more recently, and Bangladesh. And these cases have brought a strong momentum to the work of the European Union in the last few years, since 2012, not the least, and that has brought, like I said, attention, but also achieved some sort of procedural gains and some legislation undertaken by the European Union, some pressure. Mainly it's national jurisdiction in 3 of the EU member states, the UK in particular, but also the Netherlands and Germany and a few cases in other member states. An additional thing I want to clarify is that there are 2 sets of, or 2 regimes in the European Union with legislation that guides the choice of court and the choice of law. There's a Brussels 1 bis, or a revised or a recast of the Brussels regulation that deals with cross-border disputes and jurisdictional issues. And there's a Rome regime, and the regulation, Regulation 2 bis there deals with the choice of law. When it comes to jurisdiction, there's a subsidiary jurisdiction that remains with the member states. And apart from that, it's sort of a harmonized regime that tries to solve cross-border issues in these 2 areas. For the European Union, there are, of course, a lot of incentives, irrespective of the competence that I tried to explain. There are incentives for why business human rights make sense. There's the United Nations guiding principles that we've heard about previously today, that the European Union has been very supportive of. There's the idea or the concept of a single market of the European Union, which of course implies some kind of harmonization. It's an area of justice where justice should be as close to unified as possible, with the minimum standards on criminal procedures, with the rights of victims of crime, with civil proceedings being ever closer in its approach. There are trade agreements, of course, and recently there was a push to start negotiations with New Zealand and Australia, I think announced earlier this week. And there's, of course, the consumer interest with the citizens and the citizens' concerns of companies based in the EU, sort of the reputational perspective. And it's also the business human rights in terms of EU values. Article 2 of the Treaty on European Union talks about human rights, democracy, rule of law, rights of minorities, etc. And that is something that is very relevant. And the last few years, unfortunately, these very basic values that we thought we had dealt with once and for all, and we could deal with the new issues, have come back with a vengeance, looking at the situation in Poland, Hungary, Romania in the past, some concerns even in Italy and France, and on topics there are several of the other member states that are problematic. So these values are of course at the very core of the European Union, and as I said, they are becoming relevant in a development that is not very positive. When it comes down to legislation or action taken by the EU in the area of business human rights, we have the 2 regimes that I've talked about from some 20 years ago, starting in 20 years ago, Brussels and Rome. We have a Court of Justice decision from 2005 that removes forum non-convenience from the harmonized regime of the European Union. We have criminal liability in various specific areas, trafficking being one of them. And we have European Parliament action pushing for legislation, and we also have some specific pieces of legislation. Earlier today it was mentioned one of the national pieces of legislation in France, but there's also some EU law, again then within the competence of the European Union, dealing with logging of timber. So supply chain responsibility, due diligence in relation to logging of timber, shareholder rights that is relevant, that is being revised, a rare minerals directive that is hopefully being adopted this year, and also non-financial and diversity disclosure instrument that obliges member states to, companies in the member states to show increasingly more information about their business entities. This button is a bit slow, and then now it's making funny noises, so this is becoming interesting. This slide is probably difficult to read, but maybe not relevant, the details. But just to say that the European Union's work on business human rights relates very much to the work of the Council of Europe, so the 47 member states organization, as well as to the OECD and the UN. And I would like to highlight in particular that of the Council of Europe, where there's a 2016 recommendation, so all the 47 member states of the Council of Europe, including all the 28 of the EU, adopted a recommendation on business and human rights, which goes very far, and it's a recommendation, but then, as I said, adopted by the Committee of Ministers of the Council of Europe, so it has a very strong persuasive power. I think I have another slide that also tries to explain the various initiatives. So we have a number of developments in the area of business and human rights in the UN. We have a set of developments in the Council of Europe, later than the UN, but sort of picking up in the last few years with this recommendation in 2016 in particular. And the European Union has been looking at business human rights starting with in 2001, 16 years ago, with the Green Paper on CSR, and then there has been a couple of work programs set out, if you will, and in 2016, in June 2016, there was a council conclusion, so the Council of the European Union, so again, not the Council of Europe, but the Council of the European Union, that adopted a conclusion, which is the main tool for the Council, and in this case it was the Foreign Affairs Council, so it can meet in different constellations, but the ministers of all the 28 member states. And in the Foreign Affairs constellation, they adopted this resolution on business and human rights, calling for action in a number of areas of the European Union, of course acknowledging the work that has been done in terms of legislation adopted, in terms of softer measures taken, but wanting more. And in particular, they asked for the area of remedy, so saying that the other two pillars of the UNGPs, of the United Nations Guiding Principles, and with a bit of luck I can back us up to that slide. So we have the state's duty to protect, we have the business obligation to respect, and we have the victim's perspective, the third pillar there, with the right to remedy, access to remedy. And that was something that the Council then asked for particular attention to because of the many shortcomings or the lack of action in the EU member states as well as at an EU level. And one of the requests in this Council conclusion was for the European Union Agency for Fundamental Rights, where I work, to adopt an opinion advising the EU on what it could do to improve the situation. These kinds of opinion is something that the three institutions can request the agency to adopt, and we do so, they do so, and we adopt the opinions on occasion, maybe 4 or 5 times per year on different topics. And that has been a lot of the work I have done at the agency dealing with these sort of legal opinions, commenting on draft legislation of the European Union, etc. And in this case, it dealt with, as I said, access to remedy in the situation of business and human rights or business-related human rights abuse. And we adopted that opinion in April this year. And we've received good attention on the basis of this opinion, with action from the Commission being promised, and hopefully a bit more improvements than we've seen in the past coming out of this opinion. Basically, the opinion deals with 3 things: judicial remedies, non-judicial remedies, as well as implementation or flanking measures that relates to remedies. And I won't go through all the 21 recommendations of the opinion, but maybe highlighting a couple of them. In addition to legal aids and needs-based legal aid, we also call for the Commission to instigate or to prod or to stimulate the existence of crowdfunding or litigation funds or supporting processes in that way. We talk about collective redress and legal standing. There is an instrument, actually, a soft law instrument from the European Union calling for collective redress, but with very little action in the member states. We call for a stronger harmonization or a more realistic level of harmonization of damages, where presently the damages can end up being very low depending on which member state is involved. which state is involved. At the non-judicial level, we talk about obviously non-judicial remedies, including OECD-mandated national contact points. We talk about national human rights institutions' role, and also operational level grievance mechanisms in the companies. And at the implementation level, the overall implementation level, we suggest things like enhanced transparency and availability of information of which companies have what obligations, what is the situation in these companies, and trying to provide a comparative overview. And we're of course also pushing for national action plans, that they should be strong on the judicial remedies bit. So this is not much of an analysis, but a little bit of a descriptive overview of what has happened in the EU in the last few years. I tried to explain a little bit about the European Union in the process and of the agency as well. And maybe in conclusion, I could repeat a little bit what I say and try to stress a couple of points. It's clearly a difficult area. I've stressed that from the beginning. The EU is a complex beast, and the shared competence and exclusive competence of the EU and the member states makes things very difficult. So even when the European Union, the European Commission and the European Union as a whole talks about the competence issue, it's not clear where the EU has a mandate to move ahead in the area of business human rights. It's also complex in that member states typically are very keen on rebutting proposals from the EU by saying that this is no problem, we have this in place already, and it works beautifully, even though we know from anecdotal evidence that it doesn't work beautifully. So what we are trying also to do is to provide a sort of a baseline for where the member states are in order to make sure that there is clear arguments for what can be improved at the European Union level. And I get the stop sign, so I guess that means I should stop. Thank you very much.
Okay, well, thanks to both of my co-panelists for their very deep and very broad and comprehensive explanations of Alien Tort Claims Act in the United States and EU and some of the recent developments in civil litigation in the EU. I'm going to move us, as I said, in time and space to East Asia in particular, and to Japan and Korea in particular. And I'm going to begin by talking about World War II litigation in the US. That's going to help frame a couple of the issues, and then I'll look at some cases of the past 10 or 15 years in Asia that I think we could perhaps learn something from in this country, and I think will also help us understand that the U.S., while the Alien Tort Claims Act makes the U.S. kind of a natural epicenter for this, there are lots of other things going on in the rest of the world. So let me begin by, whoa. That was amazing. Let me see if I can backtrack.
A bit fast.
Yeah, sorry. I'm done. I'll see you guys later. Wow, those of you who are in my class understand how technically sophisticated I am. Okay, good. Here we go. So when I talk about World War II, most people's eyes glaze over because they assume I'm going to go back in history, and that couldn't possibly be interesting. But as I'll argue here, World War II is actually, obviously the hostilities themselves have ended, but the underlying tensions are still there. We saw a little bit of this in the United States about 20 years ago, where we saw a rebirth of what people now call Holocaust litigation. So these are cases brought by European citizens who had come to the United States and filed lawsuits for things like forced labor or slave labor. They filed cases against insurers, they filed cases against banks that had looted either their art or their bank accounts during World War II. And what we found, let's see if I can just do one of these bullet points. There we go. With regards to all the cases, and the ones I'm going to be talking about in particular involve forced labor, U.S. courts, U.S. federal courts said, sorry, these are not going to go anywhere. You have a problem of statute of limitations, right? These claims are 40 to 50 years old. They may have been good in the 1950s or so, but by 1997 or 2000 or 2005, they're obviously stale. And then a second issue was what we call treaty waiver. And here the idea is, or here what a couple of federal courts found, was that the post-war treaty mechanism, right? So when we talk about World War II in particular, and the US and Germany, and Germany and some other states as well, there are a whole series of treaties that actually resolve that issue, that date forward several decades. And so federal courts, again, sitting in New Jersey, said, well, look, when we look to individual claims, we can see, and there's clear language, that these were actually resolved by post-war treaties, right? So they said, sorry, plaintiffs, we understand that what you went through was pretty awful, but unfortunately, statute of limitations and what we call treaty waiver prevent you from moving forward. So the cases there are Ivanova versus Ford, a subsidiary of the Ford Motor Company, which was based in Germany, and Berger Fischer versus DeGrussa, which was slave laborers against the Siemens Corporation in Germany. So people tend to forget that part of it, but what they love to talk about is what they call the German Remembrance Fund. And this was a way of resolving these lawsuits and some of the underlying tensions with a major fund that both the German government and the German corporate sector contributed each about $5 billion to. And from that pool of money, they then paid out small, $2,500, $5,000, $7,500, settlement installments, if you like, to various forced laborers and others who were harmed by the war. The point I want to make, though, is that the courts themselves actually immunized the corporations. They said, sorry, no corporate liability here. It was only later, and under the strong arm twisting of the Clinton administration, I don't know if Ambassador Sheffer had to work with Stuart Eisenstadt or others on this particular issue, but this was very much a Clinton White House initiative to get the Germans and then to get the Austrians and to get the Swiss, both corporate and public sectors, to contribute to funds. And again, the Germans had it and the Austrians had it and the Swiss had it as well. And so this model of having a government-led private/public partnership, if you like, resolve these issues is now held up as a noble way of resolving some of these lingering issues from World War II. I just want to say, for purposes of this conference, though, these settlement funds were not premised on corporate liability, right? So let's move now to East Asia, which obviously fought a very bloody World War II as well. And here we find that these tensions have not been adequately resolved. And so one of the reasons we have, as you can see in the slide, over 100 compensation lawsuits filed in Japan alone, but brought primarily by Korean and Chinese victims of the war, is because there was no global settlement in the same way that we had the German Remembrance Fund. And plaintiffs and lawyers have been pushing for this since about 1991, and we've had very little resolution. In terms of the kinds of complaints they're bringing and who is bringing them, I'm sure many of you have heard of the comfort women. There's been a number of lawsuits brought by former comfort women to get compensation from the Japanese government. But again, as I said, I'm going to focus mostly on the forced labor, slave labor context. And there have also been dozens of lawsuits filed, again, against Japan, as well as against numerous Japanese corporations that used slave labor during the war. Just in terms of the numbers, around 40,000 Chinese men and boys were forcibly abducted from China and then brought to Japan in 1942, 43, 44. And from Korea, the numbers vary, but I've seen estimates between 700,000 and 1.2 million Koreans were forcibly mobilized during World War II, again, to go work for Japanese factories or ports, munitions factories, and so on and so forth. So that's the underlying issue here. And then the response, as appropriate to what we're talking about today, are these civil lawsuits again against Japanese corporations and the Japanese government. So roughly 100 or over 100 brought in Japan. Currently, There were 15 lawsuits pending in Korea, again brought by Korean victims against Japanese corporations that do business in Korea. And finally, in China, which is not quite as transparent as some of the other jurisdictions here, I've read reports that suggest that many cases have been filed, but only one court has actually accepted it. China has this strange jurisdictional system where the court itself can decide kind of on its own whether it wants to accept your case or not. And the cases were brought as early as 2000, but it wasn't until March of last year that a court in Beijing accepted one of these cases. When we're talking about corporate liability, there are obviously a number of questions we could talk about. I'm going to home in on just three, though. First is when we look at the opinions, and I'll talk about those opinions in a minute, how has the court actually conceived or constructed the underlying violation? Right. This is, for those of you familiar with the Alien Tort Claims Act, there is, I would submit, a strong condemnation, a strong expressive function when a court in Brooklyn or a court in New York said, you violated a jus cogens norm, right? The jus cogens are sort of the holiest of the holies, and when a court comes down and says that, Kiobel did, or not Kiobel, but Shell did or did not engage in genocide or slavery or what have you, that has a strong expressive function that I think many corporations, again, concerned about their reputation, may be happy to avoid. So question one, how have courts that have dealt with this corporate liability issue constructed the underlying tort? And then again, as we talked a little bit about in the two federal cases from the United States, how do we get around the statute of limitations issue? Because again, these cases are brought in the 1990s and the 2000s and as recently as 2015, 2016, 2017. And then finally, how do we get around this treaty waiver issue? So obviously, just as there were post-war treaties in Europe and the United States, Japan and Korea and Japan and China have also signed numerous post-war treaties to deal with this compensation issue. In terms of the cases I'm going to look at, there are just a few here. And again, as I said, there are over 100 lawsuits filed in Japan. Two of those roughly 100 have actually found corporations liable, right? So I'm not saying this is a new trend. This is going to rewrite the issue of corporate liability. But I still think it's significant, particularly because there are so few examples of it. I want to sort of focus on these couple of cases where courts have been able to find the corporations liable. I'll refer to them by the corporate defendant here. One is Mitsui, a company maybe some of you have heard of. It's one of the large conglomerates in Japan, and one of their mining operations in Japan. And then another one is called Adinco or Rinco, which is a port operator in Niigata, Japan. And then the other case I'll talk about briefly is a Supreme Court case from Korea that was handed down in 2012, where they said, yes, actually, despite what lower courts in Korea have held, we think that the corporations here are liable. And as you can probably predict, that has led to, at least according to my calculations, 15 lawsuits basically filed after 2012 to say, aha, well now the green light is open, so we can, we former forced laborers, if we're still alive, can flock to Korean courts. I've seen one case that has 1,000 plaintiffs in it. So that gives you some sense both of the scope of the issue and the number of people who are still living, 70 plus years after the fact, who are trying to take advantage of this newly opened floodgate. And that case was brought against Mitsubishi, the car company, and another major Japanese conglomerate. Maybe some of you drive Mitsubishi cars. Okay, so let's talk a little bit about how you construct or how you interpret the tort. Again, in the context of alien tort, usually U.S. courts will look at international law because they have to, right? They look at customary international law, they look at treaty law, and they'll try to find some kind of jurisdictional hook with U.S. domestic law as well, right? So there's this interesting cross-breeding, if you like, of international and domestic legal spheres. When we look at the Japanese decisions, many of them actually discuss international law, which I think is a helpful or possibly helpful corrective here. But when it comes time to actually attaching liability, right, that's what we're focused on here, finding corporations liable for, in this case, war crimes or forced labor or however you want to talk about it, courts are very careful to frame it as a violation of Japanese domestic law. right? So there's a way that I think if we think of these decisions as having an expressive function, in a sense, by shutting out the horror or the horribleness of calling a company a slaver or a user of other kinds of labor that violate international law or use Kogans. There's a sense that I think both these Japanese cases that I'm interested in avoid maybe some of the expressive harm that they may actually be able to deliver. Korean cases are far less interested in international law. They sort of mention it once and then that's it. There's no attempt to actually discuss or deal with it in any particular depth. Instead, they seem to be, and again, for those of you who know your history, you'll know that in 1910, Japan annexed, that's the term the Japanese use, annexed the Korean peninsula. The Koreans think of it as colonialism. And so the Korean framing of this issue is, well, that was colonialism, that was illegal, and so any acts you took while you were colonizing us or you had colonial authority over us are probably going to be de facto illegal as well. So that's how they have considered, or they have framed the tort, not necessarily about this forced labor campaign, but about the entirety of the Japanese colonial project on the Korean peninsula. So you can see how issues of nationalism work their way into these cases. One of the other results of that, I would say, is that it prevents discussion of these cases in a broader international context, such as we're having right now. Right? We're interested in see how Alien Tort Claims Act uses customary international law to prohibit certain kinds of conduct. And I would submit that by looking at this only as a matter of Japanese domestic law or framing it only as a matter of domestic Korean law, these courts are sort of shearing the import or diminishing the import of the underlying violations themselves. Let me see here. So in case one, this Mitsui decision, I won't spend too much looking at each of the decisions, but it's important because again, I want to draw these parallels between the United States and Japan. One of the issues that we've seen in a lot of the alien tort lawsuits is that there needs to be some hook to a state, right? A state liability or something like that. Only then can a corporation be liable. Alan Sykes has talked about the different modalities of corporate liability in the context of alien tort, and one of them is a use Kogan's norm, such as Professor Doyle talked about. But another one is was the state also liable? And in this particular decision, this Japanese court said, yes, in fact, Mitsui, what you did was as bad as what Japan did. You two are joint tortfeasors, right? The two of you worked in conjunction to forcibly abduct people from China and then go to Japan. And then there's later in that decision, there's a clear mention of the fact that this conduct violates, as I said before, certain aspects of Japanese domestic law. Again, I sort of have a soft spot for literature and for clear condemnation of evil, and so I bring this passage to you as well, where the court says, together with the state, Mitsui made up for the wartime labor shortage through fraud, intimidation, and violence. This was extremely evil. Just a little bit of literary flair there. But again, I think it helps us understand the importance and the severity of what's going on here. I'll skip ahead here and just talk briefly about this Korean case. As I said before, they took the sort of broader package saying the entire occupation of Japan for 35 years was illegal, and therefore any laws that the Japanese government may have passed, including the mobilization law of 1939, was de facto illegal, right? So they go on to talk about, as you see here, the concrete act of recruiting forced labor, but there's also a much deeper and more pervasive wrong here, and that is, of course, the colonization of Korea in the first place. So that gives you some sense of how courts in Japan and courts in Korea are framing this issue, this tort, if you like, of forced labor. Second issue, and this was, as I said before, fatal to the lawsuits that were brought in the 1990s in the United States, is this issue of statute of limitations, right? So how do you get around a statute of limitations, whether it's 10 years or 20 years, when you're bringing a lawsuit 50, 60, 70 years after the fact. Now, scholars would say, well, no big deal. War crimes have no statute of limitations. As Ambassador Scheffer's presentation made quite clear, that's criminal, and we're talking about civil. Right, so it's true that many scholars and the UN and UN treaties would say that crimes against humanity, war crimes, have no statute of limitations, but as we know here, we're talking about civil liability, right? And I don't think there's any jurisdiction on earth that does not have some kind of statute of limitations for civil claims. And in Japan, and it's 20 years, in Korea, it's 10 years. So how do you get around that? The ways that these courts, and these couple of decisions I'm talking about now, is to look at it from an equity perspective. The doctrine of equitable tolling, which probably you did not study in law school, certainly I did not. What this doctrine allows is to say, look, courts, we understand that you will occasionally come into case or deal with cases where the equities of the case are so awful or so one-sided that you can just sort of magically waive the statute of limitations altogether. And that, sure enough, has been where these courts have gone to sort of dismiss statute of limitations at all. So this Mitsui decision, you'll see I've highlighted or I've italicized the words. Applying the statute of limitations here would severely violate the notions of justice and equity, right? This is obviously language drawn from the equitable tolling doctrine in Japan. Skip ahead if I can. We'll talk about that later. Again, in Korea, you also see this language of good faith, prohibition of abuse. So again, here too, they're using something that we might call, equitable tolling to allow these decisions to go forward. And again, in another part of the decision, they're quite clear that unlawful acts connected to colonial rule or crimes against humanity, these terrible acts should not be dismissed simply because they are 40 or 50 or 60 years old. I won't go too heavy into the equitable tolling discussion, but just so you understand how the U.S. would come out on this, in a number of Alien Tort Claims Acts, the U.S. has said the Alien Tort Claims Act that, again, Professor Doyle read out to you not so long ago, doesn't provide a statute of limitations, right? So what we do in this context is a New York court will look at New York state law, or an Illinois court will look at Illinois state law, and a number of cases have actually been dismissed because of this. They say, well, Illinois has a 1-year statute of limitations, so sorry. That's very briefly what the equitable tolling doctrine looks like if the defendant himself has prevented the plaintiff, or if extraordinary circumstances. And that seems to be where these World War II cases I'm talking about would fall, again, if we're going to look at this from a U.S. perspective. But you've seen the language, and the same equitable or fairness concerns are animating this issue in Japan and Korea as well. Finally, let me talk a little bit about this treaty waiver issue. Again, if we think about this from the U.S. perspective, the San Francisco Peace Treaty between the U.S. and Japan very clearly dealt with this issue and said all reparations claims are waived. Of course, China and Korea didn't sign the San Francisco Peace Treaty, right? So they have their own set of treaties here. I'll talk briefly about China, and then I'm being urged to wind up, so I'll try to do that as well. If you look at the language of the China-Japan Treaty, it says that China renounces its demand for war reparation from Japan. How courts have interpreted that and how the Chinese government has interpreted that is say, yeah, China did, but 1.3 billion Chinese people have not, right? So if an individual wants to bring a case against a Japanese government actor or a Japanese corporation, it can do so. We did not waive individual rights. And a similar, let me just touch briefly about Korea here. Let's see here. This Korean decision from the Supreme Court says a similar thing. They say, look, under contemporary understandings of international law, which I think is actually a fairly significant advance, they recognize that there's individual legal personality and there's state legal personality, and they say, look, maybe back during the 1940s or 50s, states could do that, but now individuals have their own independent legal personality, and if they want to sue states, states can't, don't have the right to, don't have the ability to waive their concerns. So let me just wrap up really briefly here, if I can get this thing to work. Voila. So again, this is, we think of World War II as the beginning of the human rights movement, and I think it's interesting that 72 years after the fact, we're still talking about civil liability for World War II. Maybe we're not in the United States, but many others are. And finally, I'll end by saying, at least in these couple of cases I'm talking about, Japanese courts, Korean courts have found ways to deal with problems that U.S. courts dealing with very similar facts came out with different conclusions on. So there's some, I would submit, value in the comparative law project. And I'll end on this note. That when you look at the way that particularly the Korean cases have framed this issue, strong streaks of nationalism are very apparent and very thick, and perhaps maybe pushing the judges towards certain results. So I'll stop there and wait for your comments. Before I do that, though, let me ask if you guys have any questions that you'd like to ask others on the panel, meaning Jonas of Ursula, Ursula of Jonas. And if you don't, then I'll ask a couple, but I want to, oh, please.
I want to know a bit more about the resolution from the Council of Europe on access to remedy. I think on your slide, you had mentioned that a couple, thank you. They had mentioned several prongs that they discussed, but two of them were vulnerability. And another one was victims' rights. Can you elaborate on what they said concerning those two topics regarding access to remedy?
So I think I can. I'll find my slides here. Was it this one you meant?
No, it was one with orange and green and all sorts of things on it.
This one maybe? No.
That one.
So what we tried to do in the, so this was not Council of Europe, but this was from the opinion by the agency. So what we were saying in relation to victims' rights was that is something that where the EU has competence, where the EU has legislated, there's legislation in place, binding legislation for the EU member states since 2015. To ensure that there is victim support, to ensure that there is a cross-border cooperation on victims. So that was something we said in particular in relation to criminal law, criminal cases, that victims' rights would be something that would be important also to facilitate claims for victims. One particular opinion that we included was that there shouldn't have to be two processes, that you'd have to have a civil process as well for the victim. So to facilitate the process for the victim, it should be possible to claim, have a civil claim embedded in the criminal court proceedings. And that is something we've also argued in other contexts. And again, what we tried to do was to situate the recommendations or the advice we provided in the opinion, where we tried to be visionary and at the same time realistic, and not push for things that were too far into the future or too problematic. And here on victims' rights, there is then competence for the EU, and then we were able to, or we thought that was a more feasible proposal than many others, so a bit more concrete than some of the other things.
Thank you.
I do want to open up the floor, but I want to ask Ursula one quick thing. So you talked about this racketeering statute, where the standard seems to be a little different from the alien tort. And of course, various bodies of law have different tests for extraterritorial application. So antitrust says, will there be a direct and foreseeable effect on the United States? And so I'm wondering, maybe as you think about this, there may be different tests that you look at, right? There's Foreign Corrupt Practices Act, there's antitrust, there are a number of different tests that courts have adopted. But the question I have for you is it your submission, your contention that Jus Cogens displaces all of that? Right? If we have a Jus Cogens norm, that should be the end of discussion, and we don't need to go through these multiple balancing factor tests or what have you. We have Jus Cogens, and that leads to jurisdiction.
Mm-hmm. Not my point. I would love that were a good argument to make, but I don't think it's a good argument to make in light of both Kiobel and Nabisco. I think it makes a difference when the allegation is one for indirect liability and the allegation is one for direct liability. If there's a direct liability claim, then arguably. What the plaintiff is trying to get at is conduct that is more immediate, conduct that is more culpable to the ultimate harm that resulted. And I think that creates a significant difference from the relationship between the plaintiff and between the indirect liability defendant and the plaintiff. So I think the directness of the liability should create pause, and it should especially create pause when you're talking about a Jus Cogens violation. I think there should be inquiry into what it means for a plaintiff to allege that kind of abuse. Even, I would say, at least some nod at it, even in the Kiobel type case where there's not going to be ATS jurisdiction. But if the claim is one for even of indirect liability for a Jus Cogens violation, that violation means something. That allegation is not the same as any other violation at international law. And so it strikes me as unfortunate, to say the very least, when that discussion is not had, and it was not had in Kiobel. And it was alluded to in the most minor of ways in Justice Breyer's opinion, a concurring opinion there. So I'm not saying that a Jus Cogens claim means there always must be ATS jurisdiction, because I just don't think one can say that in light of Kiobel and Nabisco. So.
Okay, well, that was our little insider baseball discussion. We'd welcome questions from the crowd. Caroline, if you please.
Just a quick...
and if we could get a microphone.
One question on where Europe stands on these issues. I'm originally German, so I'm always interested in what's happening in Europe. I'm not really up to date, so it's really interesting to hear what's happening.
Caroline, can you pause for 1 second while we'll get you the microphone, please?
Oh, okay.
Thank you.
Okay, so just a quick follow-on question regarding where Europe stands on these issues, especially the European Union in the efforts to guard business and human rights. You mentioned an advisory opinion. I'm so sorry, I might have missed it, but which agency was it, or which institution that did actually author that advisory opinion? And I might have missed it, I apologize in advance. And then I have one other question. You mentioned the French law, right, regarding due diligence. I did hear, but I it might be very incorrect, but just vaguely that there are certain efforts at the EU level as well in that regard that might mimic somewhat what the French law looks like regarding a due diligence requirement. Can you speak to that, or do you know of any of these developments at the EU level? And then finally, regarding the Brussels Convention, and has the Brussels Convention actually been used in a way that the alien court said it has been used? I mean, not to my knowledge from a few years ago, but have you seen a more innovative use of the Brussels Convention that might mimic the ATS?
Thank you. So basically 3 sets of questions there. On the Brussels regime and the Brussels regulation, it was revised in 2012, the last time around. It's from 2001, if I remember well. And it's meant to facilitate an understanding of the regime And it hasn't been used, to my knowledge, at all in the same way as it has been, or as the Alien Tort Claims Act has been used in the US. A study that looked at these types of cases showed that only around 20 cases in the last 25 years against European courts, or courts in European Union member states. A few more if you add Switzerland, that has had some legislation, litigation. So very few cases, and very few cases have been won on behalf of the plaintiffs. And the problems that have been clear from these cases is often discovery, which is something that only exists in the UK, more or less, in the European Union, where other member states have a very complicated scheme for accessing documents in courts. You basically have to know what document you want, not courts, sorry, in companies. You have to know what document you want, and you sometimes even have to pay for the process of getting the document. On the advisory, on the second, or on the second question, this was an opinion, an 80-page beast drafted by the European Union's Agency for Fundamental Rights, so where I work, and I drafted it, so I know that quite well. And on the third question, which was your first, sorry, maybe due diligence. So there is this French law from, I think it was finally adopted in January this year. End of last year, or maybe early this year, Holland adopted a piece of legislation relating to children, so very sectorial specific thing, child labor. And then there's, of course, from a few years back, the Modern Slavery Act in the UK. And these have all this due diligence or an equivalent. And some of the legislation I mentioned on the EU level, the logging of timber and the rare minerals, has this due diligence feature built in. But it's very specific to the area of business. And there is the French is pushing very much for the EU to take action, but it's only pushing. There's no concrete suggestion. But of course, that would help for leveling the playing field across the area of justice, as I said, or the single market. So that is something that I guess is coming, and we're pushing for it a little bit also in our opinion. We're saying that one should at least look into the consequences of having a stronger due diligence across the board for the European Union.
All right, well, according to that clock at least, we're a couple minutes beyond. So I think if you guys have questions, I would encourage you to come up and speak individually to the panelists here. But I hope you will join me in thanking them in applause for their presentations. Are you going to speak now, Avi? Are you going to speak now? Yeah. Okay. Before I think Professor Kiobel will make some concluding remarks for the conference. Thank you.
So I'm the last person who stands between you and going home, so I'll try not to abuse that. So thank you all for being here today, and thank you particularly to the panelists. I just want to sort of try and draw a few strands together, though I recognize how perhaps impossible that task is. By at least one account of the top 100 economies in the world today, only 31 of those are nation states. The other 69 are corporations. Royal Dutch Shell, which was the corporation in Kiobel, is the 18th largest economy, just after South Korea, just ahead of Mexico, and Jonas, actually, just ahead of Sweden, too. So the sheer economic scale of these companies, coupled with globalization, I think demonstrates with stark clarity how widespread is corporate influence, for good and for ill. So, based on what we've heard today, it hardly seems an outsized assertion to contend that these juridical entities, which enjoy their existence by virtue of law, should also be held accountable under law. The United States Supreme Court has famously recognized in Citizens United that corporations are people too. They enjoy the protections, for example, of the First Amendment. Perhaps accordingly, to use a now defunct judicial phrase, corporations should enjoy the bitter with the sweet. As Ambassador Scheffer noted in his remarks, that while corporate impunity is not going away, the tide has turned. In discussing the Universal Declaration of Human Rights about 20 years ago, the now past Louis Henkin famously asserted that the application of human rights obligations on every individual and every organ of society excludes no one, no company, no market, no cyberspace. 6 years ago, Professor Kaye referenced the Human Rights Council's the guiding principles on business and human rights. They identified state obligations to protect human rights, but also for business enterprises to do the same, stressing the need for rights and obligations to be matched to appropriate and effective remedies when breached. But what does that mean? Indeed, even as it seems to have been predicted today by many here, the Supreme Court holds in Jesner versus Arab Bank that corporations may be liable under the Alien Tort Statute. What then? What kind of relief? These are all variations on a befuddling theme that's not unique to international law. The noble but often elusive principle that Blackstone identified hundreds of years ago and shows up in every American constitutional class in Marbury versus Madison is that every right, when withheld, must have a remedy, and every injury its proper redress. It is, of course, easier said than done. But I think today's conference, our panelists, have gone a long way to helping realize the scope and application of a remedy, and that corporations must bear some responsibility. And we have benefited from so many of our panelists' insights on criminal and civil liability, as well as externally and internally imposed restraints, principles, and ethics. Whether it is through a revised appreciation of the Nuremberg Tribunal's understanding of corporate liability, the Rome Statutes drafters, or how to incentivize sharing about corporate supply chains. I want to thank everyone, the panelists, you, the public, the audience, the International Law Journal students, our fantastic law school staff, for ensuring that today's conference has been such a terrific event. I know that many of our panelists have come from far away, across the Atlantic even, and we appreciate your dedication of time to this conference, and we're very much enriched for it. I want to particularly thank Dean Scharf for his energy and commitment to this program, as well as Professors Tim Webster, Professor Andra Burke-Robertson for helping shape and develop the conference. To thank all the law students, the International Law Journal students in particular, for their hard work in making this event possible. Finally, most importantly, I want to thank Eileen Drabowski, who so expertly and deftly made this event happen. She spent many hours and energy ensuring that you all got here, that you all could eat and survive, and that you all might go home. So thank you, Eileen. Finally, I want to remind you this conference is not just one static event. It's part of a dynamic process. It, of course, is being screened, televised all along. But panelists have shared with us all these critical ideas. They are now going to be published. They're going to be edited and worked on, and they will have a legacy, hopefully for many years to come, and really will impact this dialogue over corporate responsibility for human rights. And so I want to thank you all for making that happen. And finally, really finally, please join us all in the rotunda for refreshments and more informal discussion, and have a wonderful weekend.